As a mom and a policymaker, I know how important it is to protect the economic security of pregnant women and working families. Unfortunately, our current laws are inadequate, and many pregnant workers are placed on unpaid leave or forced out of work when they only need a simple accommodation to stay on the job during their pregnancy. Today, we are holding a legislative hearing on H.R. 2694, the Pregnant Workers Fairness Act. This bill takes an important step to guarantee that pregnant women will get reasonable accommodation that will allow them to stay in the workplace. I would like to thank our witnesses for being here to provide important insight on the discrimination and hardship pregnant women face when they are denied reasonable accommodations in the workplace. I also want to thank Judiciary Committee Chairman Jerry Nadler, the lead sponsor of this bill, for taking time to join us this morning. According to A Better Balance, 75% of women will be pregnant while employed at some time in their life. Women are increasingly either the primary or co-breadwinners of households, and as a result, more pregnant women work later into their pregnancies. In fact, research suggests that more than 80% of first-time mothers work until their final month of pregnancy. I know I did. Pregnant workers may need reasonable accommodations to protect the health of both mother and baby. Reasonable accommodations can range from providing seating, water, and light duty to excusing pregnant workers from tasks involving dangerous substances. They do not need to be, nor are they typically, complicated or costly. But when pregnant workers do not have access to the reasonable workplace accommodations they need, they are often forced to choose between their financial security and their pregnancy. The consequences can be devastating to their health and security. It's also important to note that women of color are overrepresented in low-wage, physically demanding jobs and are therefore disproportionately affected by a lack of access to reasonable accommodations. In 1978, Congress first recognized the responsibility to provide pregnant women with fair and equal treatment in the workplace when they passed the Pregnancy Discrimination Act. The law clarified that discrimination against pregnant workers is discrimination on the basis of sex under Title VII of the Civil Rights Act of 1964. The law also requires businesses to treat pregnant workers as they would other physically impaired workers. Yet, 41 years after the passage of the Pregnancy Discrimination Act, federal law still falls short of guaranteeing that all pregnant workers have reasonable workplace accommodations. Under current law, a pregnant worker must show that her employer accommodated similarly situated coworkers, a burdensome and often impossible standard to meet. Similarly, the Americans with Disabilities Act covers pregnancy-related impairments, but leaves women with less serious pregnancy-related impairments or who simply need accommodations without legal recourse. Even the Supreme Court's decision in Young versus UPS, which affirmed pregnant workers' rights to reasonable accommodations under the Pregnancy Discrimination Act, has not provided workers or businesses the clarity or legal certainty they need. In fact, since Young versus UPS, approximately 70% of courts have denied reasonable accommodations for pregnant workers. Pregnant women today continue to suffer workplace discrimination at an alarming rate. According to a 2012 survey, more than 60% of workers have seen pregnancy discrimination on the job. For these women, being pregnant can mean losing a job, being denied a promotion, or not being hired in the first place. Guaranteeing that pregnant workers have a reasonable accommodation in the workplace is a crucial step to eradicating pregnancy discrimination. And without federal protections for pregnant workers, several states from across the geographic and political spectrum have taken action to fill the void. My home state of Oregon is one of those helping to lead the way. Earlier this year, the state legislature passed a bipartisan bill to require employers to provide reasonable accommodations to applicants or employees with known limitations related to pregnancy, childbirth, or related medical condition unless it would impose undue hardship. And as of this month, 27 states and the District of Columbia and 4 cities have required employers with more than 15 employees to provide accommodations, bringing certainty to business, preventing costly disputes, and importantly, keeping pregnant women safely on the job. But without a federal benchmark, workers and employers are left with a patchwork of laws that provide strong protections for some and no protections for others. We need to make sure that all pregnant workers, regardless of where they live, can access the protections they need to stay in the workplace. And that's why we're discussing the Pregnant Workers Fairness Act today. This bipartisan bill would establish a pregnant worker's right to reasonable accommodations and guarantee that pregnant workers can seek those accommodations without facing discrimination or retaliation in the workplace. The Pregnant Workers Fairness Act is an opportunity for Congress to finally fulfill the promise of the Pregnancy Discrimination Act and take an important step toward workplace gender equity, healthy pregnancies, and the economic security of all pregnant and parenting women and their families. I welcome this opportunity to work with my Republican colleagues to move this bill forward in a bipartisan manner. I request unanimous consent to enter 2 letters into the record, one from the International Brother of Teamsters and more than 100 stakeholder groups, another one from more than 100 stakeholder groups, both in support of the Pregnant Workers Fairness Act.